Okay, all the 1Ls should remember me. I'm Dean Langan from Orientation. I want to welcome you to our final round for the Bainbridge competition. This is our 41st annual competition. You're going to hear a lot more about it when you get into LP2, and you're going to have an opportunity to do the same thing that our two finalists are here doing today. And you're going to have a great time doing it, and you're going to be one of the finalists next year. At least two of you will be. So I want to thank you all for being here. This is an important competition that we do. We find that our students do very well in Moot. Is my voice getting louder? We find that our students do very well in competitions around the United States in Moot Court, because you all have great oral skills. We know that from class because you like to argue all the time in class with us. But we're going to find two professional students today who are our finalists, Matt Cohen and Nicole Tamargo. They are 2L students, so they sat in your seats last year and watched and said, I can do that, and now they're here today. We also have a great panel of judges, two of whom are actually alumni from the law school. So again, maybe something you'll do once you graduate is come back and be judges. I don't want to take up any more of your time. I'm going to turn it over to Dean Berman, who is the faculty advisor for Moot Court, and she's going to give you some more information. So thank you for being here. Watch and learn.
Good afternoon, everyone. Some of you are sick of hearing my voice. You've been hearing it for the last hour and a half. I apologize. I'm going to be really brief because Dean Langan said just about everything that I had wanted to say to you, and so she covered all of it. Except I want to say one thing. I hope that all of you will listen to today's argument and have in mind that you can become members of Moot Court. There is a GPA eligibility requirement, but otherwise you should expect to hear from our wonderful 2L and 3L and Flex students, Moot Court members, in a little while, and they will explain to you afterwards how you do become a member of Moot Court. Being in this co-curricular honor society really is an honor, and it is an adventure, and it is an experience of a lifetime. And I am partly here today in this role that I have at Toro Law Center because I was a Moot Court member, and I was on the e-board of Moot Court, and I won Bainbridge. So I hope that one of you has the same experience that I had, because it changed my entire law school experience. It changed my really the way in which I decided to live the rest of my life in terms of my professional career. So this is really going to be an event that I hope you'll all remember. I want to turn it over to Fatima Pasha, who is our editor-in-chief of Moot Court, and she'll take you through the rest of the competition until we begin.
Thank you. Thank you, Dean Berman, and good afternoon, everyone. Welcome to our 41st annual John S. Bainbridge Moot Court competition. As she said, my name is Fatima Pasha. I'm the editor-in-chief of this year's Moot Court Honors Board. It's a pleasure to be here with all of you this afternoon and to present our two finalists, Nicole Tamargo and Matthew Cohen. With the aid of our advisors, our wonderful and extraordinary e-board, and the Office of Administration, this event was made possible. We are honored to have our esteemed judges here with us this afternoon. We have Dorian Glover, the past president of the Nassau County Bar Association. We have Cornell Baus, the president of the Suffolk County Bar Association, and the Honorable Mark Cohen, our jurist in residence and current professor here at Touro University. As most of you have seen in the program, this is an issue regarding the constitutionality of an immigration law that requires deportation of legal residents who have been convicted of a crime of violence. And without further ado, I present to you the final round of the Bainbridge Moot Court competition. Good luck to you both. Bailiff Cosentino, you may proceed.
All rise. Oyez, oyez. All persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, everyone, and please be seated. The first case on our docket this afternoon is Shiv Roy Petitioner against the Department of Homeland Security and the U.S. Immigration and Customs Enforcement. Both sides ready? Would you please state your appearances?
The Respondent, Your Honor, Matthew Cohen.
The Petitioner, Your Honor, Nicole Tamargo.
Mr. Marco, are you ready to proceed?
Yes, Mr. Chief Justice.
Please proceed.
Good afternoon, Your Honors. Mr. Chief Justice, may it please the Court, my name is Nicole Tamargo, counsel for Petitioner Shiv Roy. I would like to reserve 1 minute for rebuttal.
That's fine. Thank you.
Thank you, Your Honor. Would this Court like a brief recitation of the facts?
Yes, very briefly.
Your Honor, the petitioner, Miss Roy, is a United States resident, married to a United States citizen, and she's a sole caretaker for her sick mother. She's financially dependent on her as well. And to pay the medical bills, Miss Roy stole a cell phone from the tenant that is in her home, and this is why we're here today.
And so, Ms. Tamargo, your client engaged in what was a burglary under the law of Tarovia. Isn't that true?
Yes, Your Honor. She committed a crime. However, that's not what's at issue. What's at issue that this case is about is that which this court has already established precedent on this issue is about the violation of a lawful permanent resident's due process rights by imposing a
Your
savage
client,
penalty.
Ms. Tamargo, may have certain rights as a lawful permanent resident, but in order to set the facts clear for the record, she committed a burglary which under the law of Tarovia is a violent crime, is it not?
Yes, Your Honor. However, the statute defining the crime of violence is too vague, which brings me to my first point.
Before you get to your first point, can you reconcile Guardado for me as it relates to the substantial risk?
Yes, Your Honor. Guardado relates to substantial risk. However, it is a Fifth Circuit case, and the Supreme Court in Sessions versus DiMaia in 2018 held that imposing sanctions like the Armed Career Criminal Act violates due process. And this court should reverse the lower court's decision to deport Miss Roy and hold that deporting Miss Roy would be a violation of Miss Roy's 14th Amendment due process rights for the following 3 reasons.
Thank you.
Can you be specific? You say due process, and you're going to be throwing that out a lot in your argument. What due process rights?
Yes, Your Honor. The due process rights of life, liberty, or property may not be taken without due process of law. And here, Miss Roy's life and liberty are being taken away by the INA statute that crime of violence is defined as being too vague. First, in 18 U.S.C.
Question, Ms. Guardado, I don't mean to interrupt your answer to Justice Baus, but in the end, is it the substantial risk that's involved, not just merely what happened in the case involving your client?
Yes, Your Honor. The substantial risk is too vague. The definition of substantial risk is too vague. It's extremely difficult to define. And in Sessions versus DiMaia in 2018, it requires the justices state how it requires judges to have to predict the kind of behavior that someone is committing. And as Justice Baus was just stating before about due process, it is stated to have due process because the void for vagueness doctrine, as stated in Sessions, guarantees that ordinary people have fair notice of the conduct that the statute prescribes. And here, Ms. Roy did not have fair notice of the ordinary conduct.
But in Sessions, didn't that case suggest that the question devolves down to the ordinary case? An ordinary case of burglary of a dwelling, and I understand in this case, the burglary is peculiar. It's the burglary in her own home. She had no lawful right to enter that room because that room was rented to the tenant. And in simple terms, that entry is a, quote, substantial risk of violence by its very nature, is it not?
Your Honor, respectfully, that is not what is at issue here. What is at issue is...
I actually think it is at issue. I think Chief Judge is correct. What facts can you point to that demonstrate that she didn't have that mens rea?
Your Honor, Miss Roy, she's not an ordinary case. This is an extraordinary case where an ordinary crime of violence, an ordinary case of burglary, people are not getting hurt here. She did not, no one got hurt. The Torrevilla statute, for example, is overbroad and unconstitutionally vague since it defines crime of violence to include risk of physical force against a person. And it is undisputed that Miss Roy did not use physical force against any person.
We understand that. The record is clear that in this case, your client did not use physical force. But is that the analysis that we should undertake in this court? Is it not, again, the issue of substantial risk in an ordinary case? And an ordinary case of burglary of a dwelling, does it not involve that substantial risk of violence?
Yes, Your Honor. It does not involve a substantial risk because Miss Roy intended to make sure that there was no harm. The tenant was not home when she stole the cell phone. It was a cell phone. She's not some hardened criminal. She simply stole a phone from the tenant. And third, deportation is a savage penalty because the grave nature of deportation imposes a life sentence on minor acts. And in Sessions versus DiMaia in 2018, the court states how the Armed Career Criminal Act, ACCA's residual clause, and Section 16B's residual clause are linguistically similar. And in Johnson
versus... But the facts in that case, I mean, we have two different acts with Sessions, so that doesn't really help me.
Yes, Your Honor. However, in Sessions, relying on Johnson, they mention how 18 USCS Section 924E2B was unconstitutionally void for vagueness under the Fifth Amendment's Due Process Clause. And further, to emphasize this court in Sessions, this court referenced the ordinary case approach that allowed the courts to apply the residual clause without inquiring to the individual facts to the prior crime. And Congress wanted judges to look into a felon's actual conduct. It presumably would have said so in other statutes, in other contexts, to speak in just that way. And as the record reflects on page 1, Miss Roy's husband cannot care for Miss Roy's ill mother since he is out on disability.
Your argument now is also in the alternative for discretionary relief based on what are the extenuating circumstances here, is it not?
Yes, Your Honor. And here, Miss Roy is not in the ordinary case. She is an extraordinary case for this issue. And just like Sessions relied on Johnson, we already have the precedent here. This court has already decided. This court has already made the decision that the statute is vague. In Johnson, it was defined as serious potential risk. In Sessions, it's defined as substantial risk. And here, it's also mentioned that substantial risk in the Torrevilla statute against substantial risk that physical force against the person will be used. And here, Ms. Roy didn't use any physical force. She couldn't have because the tenant wasn't home. And
Counsel, are you arguing that the burglary conviction should not have laid in the first place?
Your Honor, that's not what I'm arguing.
Well, let me just ask you this.
Yeah.
There are elements to burglary. Is it your position that one of those elements are missing, and this is not a violent offense that should have been that she was convicted of?
Your Honor, what I'm stating is she was convicted of a crime of burglary. That's already been decided. She served her 18...
And that's a violent crime.
Yes, Your Honor. However, the violent crime clause is too vague in Section 16B's residual clause defining crime of violence. Because she did not use physical force, there was no risk. And for a person of ordinary and reasonable intelligence to have to infer, it's too vague. It produces so much unpredictability.
In the statute, where's the requirement that she needed to use physical force? Because I don't see it.
In the Torrevilla statute, it states substantial risk that physical force against the person will be used. Against a person.
The substantial risk, but your comment was that she did not use physical force. She didn't have to. It just had to be the substantial risk, as our Chief Judge mentioned.
And if I may, you haven't jumped the hurdle of 16B about substantial risk yet, because they're saying, in essence, whenever private residence is broken into, there is always a substantial risk. I need you to jump that hurdle.
Yes, Your Honor. Section 16B, as incorporated to the INA, is unconstitutionally vague. And there was no substantial risk because the tenant wasn't home. She intended to make sure there was no risk.
What would have happened, and we're not engaging in this as speculation, but this is under the guise of, most respectfully, substantial risk. What would have happened if a neighbor had seen this and attempted to remove the illegal entrant into that room? Is that not the same substantial risk? And isn't that why burglary of a home by its nature carries with it the substantial risk of violence?
Your Honor, respectfully, no one broke in the house. There was no risk. She calculated this so well that there was no risk of harm. There was no substantial risk that anyone would be hurt. She was just trying to help her mother, and she's not some hardened criminal. And to Petitioner's last point, deportation is a savage penalty because of the grave nature deportation imposes a life sentence on minor acts. And as the record reflects on page 1, Miss Roy's husband cannot care for Miss Roy's ill mother. No one else can take Miss Roy's sole caretaker role. It is inhumane to deport someone who's a sole caretaker.
May be inhumane to some degree, painful to a large degree, but isn't the very nature of removal or deportation the stuff of separation of families?
Yes, Your Honor. However, Miss Roy is not some hardened criminal. She served her time for the crime that she committed, and now she is suffering, as I quote from Fong Hao Tan versus Felon in this court in 1948, a lifetime of exile, where the courts describe how deporting someone is almost worse than the crime itself because they're being sentenced to a lifetime of exile, a lifetime away from their home, of their community, of their established means and livelihood. And in Fong, the petitioner was an illegal alien who was convicted of murder. Here, Miss Roy's not a murderer. She just stole a cell phone. And in Fong, this court reversed the lower court's decision to deport Fong. And here, Miss Roy is just a wife trying to provide for her family, take care of her mother, and be the best citizen that she could be.
So what are then the humanitarian considerations that we should take into account here? She's not really spent that much time in this country. She certainly has relationships with her husband, and she is the sole support for her husband. And in the end, though, should that be a factor? If she's not spent that much time to have connections to this country, and while you have said several times she's not a hardened criminal, there's no doubt, respectfully, she's a criminal.
Your Honor, respectfully, Miss Roy's husband is a United States citizen, and he is relying on her. A United States citizen is relying on her to provide, and she's the dependent role in their family. And this court has already decided that we already have precedent on this issue that's been established that Section 16B is vague. And furthermore, the petitioner respectfully requests that this court reverse the lower court's decision to deport Miss Roy, since precedent has already been established and this court has already decided.
What if I were to think about what Mr. Cohen's going to bring when I ask him the question regarding substantial risk as it relates to a very good point you made that no one broke in. And I'm anticipating Mr. Cohen is going to say that it's still burglary and she was convicted of burglary. What say you?
Yes, Your Honor. She was convicted of burglary. She's already been punished for that crime. Respectfully, the petitioner requests not to be deported. And I see we are out of time, Your Honors. May I briefly conclude?
Yes, please. Thank you.
To finish up your question, Your Honor, she served her time. She served her 18 months in prison, and she should not be penalized for a crime she committed that she already sentenced and served that time for. Your Honors, please consider this domino effect that deportation would have on Ms. Roy's family. It would be detrimental since she is the glue that is holding them all together. Thank you, Your Honors, for this opportunity to be heard.
Thank you.
Thank you, Ms. Tamargo. Mr. Cohen, for the respondent.
May I proceed, Your Honor?
Please do.
Good afternoon, Your Honors. May it please the Court. My name is Matthew Cohen for the Respondent, the Department of Homeland Security. The case today concerns the foundation of this country we call home, that foundation being the citizens of the United States of America.
Mr. Cohen, let me ask you this. Where is the physical harm or risk thereof in a circumstance as in this case? Where is it? Because as we've outlined, the record of this case is clear. It was an entry into her own, in a room in her house.
That's right, Your Honor. The language of United States Code 16b, which is at issue here, does not state that force must be used. It states that there must be a risk of force. And the inherent nature...
Substantial risk.
That is correct, Your Honor. Substantial risk that force be used upon a person. Now, in this case at hand, and the ordinary nature of burglary always suggests that there's a use of force associated with the offense. Specifically to this case, the petitioner lives in the same dwelling as the victim. Regardless if the victim was home or not, there was still a risk that the petitioner could use force against the victim.
So explain to me the substantial risk. Your argument is there's a risk, which frankly is not the right argument. It wouldn't be a substantial risk. So she owns the home, the room is rented, apparently they get along, they have a certain friendly relationship. That's what I'm taking from this. There's items in the room. She goes in when she knows he's not home. She gets it. Now, what if he was home? Are you telling me if he was home, there would have been violence? I mean, where do you see substantial risk? Because frankly, I'm not seeing it.
Respectfully, Your Honor, this court in 1951 on the case Jordan v. DeGeorge found that impossible standards of specificity are not required. Therefore, to the statute, United States Code 16b, we need not have a definite standard as to what constitutes a substantial risk. However, although the victim was not there, there is still that risk posed. The government is not saying that if the victim was at the home at the time of the crime, that violence would have ensued. The government is saying that there is a risk that force could have been used upon the victim.
And to the point of Justice Baus, risk is not sufficient. You need substantial risk. There's always a risk. You never know what's going to happen next. But in the case of an unlawful entry into, in this case, a room, where is the inherent substantial risk when that room is in one's own house?
Your Honor, under the common law, burglary has always been held to be an inherently dangerous crime. More so, it is one of the few offenses not subject to the murder doctrine. It's a standalone, ordinary, and serious offense. Now, to the point that the victim lived in the same dwelling as the petitioner, that poses that there's a substantial risk. The victim could have came home and violence could have ensued. More so, there is that risk, that force, substantial risk, that force could have been used in this offense. Now, for the government's first point.
So again, just to clarify for us, the government is saying it was inherently a crime with a substantial risk, not merely a risk.
That is correct, Your Honor. The crime of burglary always poses a substantial risk that force be used. Now, for the government's first point, the language of the ACCA clause differs from that of United States Code 16b. First, it's unlikely that this court intended for its decision in the case Johnson versus United States to serve as the backbone for continuously striking down statutes.
Can I interrupt you a second? I'm struggling with a different point, and that is our ability to exercise discretion as it relates to her life circumstances. Can you reconcile that for me? You know, where we should place our interest in light of the harm that it could pose to her by being deported?
I can, Your Honor. The petitioner cites to the case Fong Hao Tab vs. Felon, which is largely irrelevant to the case at hand. However, it is a mere illustration that humanitarian factors do exist. Now, the government is not denying that humanitarian factors exist in this case. However, those factors are outweighed because the motivation surrounding the petitioner's conduct That being the financial struggle and the inability to care for both her ill mother and husband is not going to change. Mrs. Roy will still be struggling financially, and we are not to say whether or not she could commit this offense again. More so, the laws are in place to deter criminal conduct. And if this court was to show sympathy for every single offense, these laws would serve no purpose. Now, as for the government's first point, 3 years later, in Sessions versus DeMaia, this court went too far in its application of Johnson. Again, in a 5-4 decision, which included 2 dissents, this court made the wrong decision.
I'm sorry, what?
This court made the wrong decision.
That's what I
Sessions,
thought you
Your
said.
Honor.
Can you explain that why?
Yes, Your Honor. To support this assertion, I'll highlight the differences between the ACCA clause and United States Code 16b. Now, the ACCA clause states conduct that presents a serious risk of injury to another, whereas the language of United States Code 16b, as seen in Johnson, is substantial risk that force be used against a person or property. Now, at first glance, these statutes seem very similar, frankly because they are, which explains why this court robotically applied the findings of Johnson in this case, Sessions. However, the difference is that the language of the ACCA clause focuses on the result or a consequence of a crime, that being injury occurring, whereas the language of Sessions is focusing on conduct within a crime, that being the use of force. Now, this court's caution in Johnson is correct because it's entirely speculative as to what the result of a crime will be. For example, not every car accident results in injury. Therefore, to make a determination as to what the result of a crime will be is entirely open-ended. Now, where this caution is correct in Johnson is incorrect in Sessions because it is not speculative that force will be used in the commission of burglary. It's entirely implied. To commit burglary, you must use force. You can't simply think...
Even force if it's your own home? Where's the force?
Your Honor, as I've mentioned, the language of 16b requires that a risk force be used. It does not require that force must be used against the person.
Substantial risk. Can you say substantial?
My apologies, Your Honor.
Try
It is that a substantial risk
Thank you.
be used to the person. So therefore, this court's caution is correct in Johnson but incorrect in Sessions. Now, as for the government's second point, specific standards are not required and burglary is repeatedly held to be a crime of violence. As I've mentioned, this court in Jordan v. DeGeorge states that there need not be specific standards. Furthermore, the ACCA clause, as seen in Johnson, even lists burglary as an enumerated offense. The petitioner repeatedly stated that no force was used and this crime was not violent. However, burglary is an aggravated felony, which is also listed under a crime of violence, regardless if violence is present or not. Now, to further support this point, the government cites to the case United States v. Guadardo, which the Fifth Circuit found that whenever a private residence is broken into, there is always a risk that force be used.
Stop. Broken into her home. Speak to that.
Your Honor, as the record reflects, the door was open. However, we already know that the petitioner was convicted of felony burglary, and burglary requires the unlawful entry. Therefore, merely because the door was open does not mean that Mrs. Roy did not break into a residence that she was not allowed to.
We have to take the facts as we have them. We're not going to relitigate the lower court. There's no indication that there was any force, breaking and entering, through a window, anything. She entered the room, right? The room in her own home. So I don't want to cut you off too much, but speak to that force or the lack of it.
Your Honor, again, it is the substantial risk of force, not that force need to be required in this case. Now, on page 2 of the record, it's evident that Mrs. Roy waited for the victim to leave the home before committing the crime. This act demonstrates to the government that the petitioner was well aware that there was a risk of force could ensue. And instead, she waited for a time where that substantial risk might be at a smaller potential. However, that action does not excuse that the risk of force is still substantial.
Would you agree that she was trying to avoid the risk of force? Would you agree with that?
I would agree.
Okay.
However, her avoidance of the risk of force does not negate that there was a risk of force present in the commission of the burglary here.
Other than the listing of that felony as a violent crime, is there any other indication that there was force or violence here, other than the listing of a burglary as a violent crime?
Your Honor, as the record reflects, there is no instance of violence being present. But as I've mentioned, burglary, which is considered an aggravated felony, and aggravated felonies are included under a crime of violence, regardless if violence is present or not. Therefore, merely because there was no violence here does not mean that burglary is not a crime of violence.
Mr. Cohen, your colleague urges that we exercise our discretion in favor of her client. How would we do that in this case? How would we weigh what's an appropriate circumstance? We know the record shows that her husband's on a disability and she is the sole support for him. Is that enough for us to exercise our discretion and say, well, in spite of everything else, she can stay?
No, Your Honor, that is not enough. The immigration...
Then what is enough, respectfully? I kind of thought that was your answer, but go ahead.
Respectfully, Your Honor, the humanitarian factors are not at issue here. We are dealing with the potential vagueness of a statute. But further, the Immigration's Nationality Act states that any alien who is convicted of an aggravated felony after entering the United States is deportable. Therefore, Mrs. Roy was given clear notice that her actions could subject her to deportation and would not only have consequences on herself, but also her family.
My question is, maybe this is one, do we have the discretion to say she should stay because of humanitarian factors? Just do we have that authority as a court to override the statute?
Your Honor, this court is able to view the humanitarian factors. However, as I've mentioned, the issue at hand today is regarding potential vagueness of a statute, not the surrounding circumstances of the offense of burglary.
But respectfully, indulge me for a minute. If we were to go down that road, that is, consider humanitarian factors, why would the government say they're not applicable here, moving away from the argument of the statute's not vague?
Your Honor, the humanitarian factors surrounding this offense are outweighed here because, as I've mentioned, the petitioner's conduct was motivated by financial struggle, and Mrs. Roy is still struggling financially. There's no indication that she's received a new job or that she'll have an increase in pay, and therefore, that financial struggle is still present after Mrs. Roy finished her jail sentence. Further,
I'm not sure that speaks to the Chief Judge's question on discretion, and I think it speaks to the fact that hard times may be coming. But I would really like to know, where you feel our discretion is in light of the humanitarian concerns that we might consider when we think about this case.
Your Honor, in terms of humanitarian factors, this court can look at the humanitarian factors in regards to deportation. However, deportation is not at issue here. What's at issue is the potential vagueness of United States Code 16b, and therefore, the court should not consider these humanitarian factors when debating whether or not the statute is vague. Now, as I've mentioned, we have these laws in place to protect the American people. If every humanitarian factor was to excuse the conduct of convicted felons, then these laws would serve no purpose. Further, the petitioner mentions that burglary is not a serious offense, and further, that deportation is a very severe or savage penalty. That is true that deportation is a severe penalty. That is because felonies are also very serious conducts, and therefore, those serious convictions must be backed with the just punishments. Now, in order to continue to protect the citizens of the United States and to keep the integrity of this country, this court must find the language of United States Code 16b sufficient. And for the foregoing reasons the government has just presented, the respondent asked this court to affirm the decision of the United States Board of Immigration Appeals from the 18th Circuit and grant the application to remove the legal resident. Thank you, Your Honors.
Thank you, Mr. Cohen. Ms. Tamargo, do you wish to use your rebuttal time now? Please.
Your Honors, I would like to address 3 points. First, Sessions and Johnson were correct in holding that the statute was vague. This court has precedent and has already decided and established that Section 16B's residual clause is unconstitutionally vague. Second, to my respondent's analogy, not every car accident results in an injury, not every burglary ends with violence. Third, as Chief Justice Cohen stated to my adversary, there was no risk. Ms. Roy is not some hardened criminal. There is no just or good cause behind deporting Ms. Roy. Your Honors, please consider the domino effect that deporting Ms. Roy would have on her family. She's the glue that is holding them together. Thank you, Your Honor, for this opportunity to be heard today.
Thank you very much. This court will recess and render its decision. Thank you.
All rise. All rise.
Good afternoon again, everyone, and please be seated. We've been asked to introduce ourselves, and while our name tags presumably are here, I will ask each of my colleagues to introduce themselves first, and then I'll say my name. Justice Baus.
Good afternoon. Cornell Baus, a pleasure to be here. I'm actually an alumnus from Toro, 1989. Now you know how old I am. I'm currently the president of the Suffolk County Bar Association. I'm very proud of that as well. Just 30 seconds on that. I know when I was in law school, after I got out, the first thing I did was join the Bar Association of my home county, and I've never looked back. I'm extremely successful. I feel more successful now being the president of the bar, but I urge everyone here, while you're in law school, there are no dues. The Suffolk County Bar Association, they do nothing but mentor and help you as you achieve your career goals and pass the bar. And after you pass the bar, become a member. If it doesn't work for you, you don't have to stay a member. But I'm telling you from personal experience, because I sat in those chairs. I've lectured here. I think the building I went to was a little different. I don't know. I think it was a beautiful red brick building in Huntington. But the spirit was there, and Dean Glickstein was everywhere. But anyway, I'm proud to be sitting as a judge today, and I'm proud to be sitting with my esteemed colleagues. Good afternoon.
Good afternoon. I'm Dorian Glover. I echo my colleagues' comments. Class of 1996, Toro, give that up. I'm the chairman of the Appellate Division Grievance Committee, past president of the Nassau County Bar Association. I'm the chairman of my library board. How about that? That's exciting. If you go to Hempstead, you'll also see that there's a street named after me. It's Dorian R. Glover Way. And I'm here to also let you know that the Nassau County Bar Association is here for you. We are your bridge to your practice, as well as your opportunity to meet attorneys and judges, to have that opportunity to network. And I joined as a law student member while at Toro, and it's free, just like Suffolk County Bar Association. You want to start to read the periodicals that come out because you're going to be on this side before you even know it. So I'm also an adjunct professor here. I teach law practice and business management, as well as racism in American law, and my compliments to both sides.
Thank you very much. I am Mark Cohen, and many of you may know that I teach at the law school. I've been teaching here as an adjunct for well over 32 years. and I have the most fabulous title. I'm the Distinguished Jurist in Residence, and it really is a wonderful thing. I was a judge for almost 15 years. I worked in Homeland Security for 5 years after 9/11, and before that was a prosecutor for 25 years, and before that was actually an appellate law clerk right out of law school. But the most exciting and interesting job that I've ever had is being a teacher right here in this law school. One thing I want to echo, and it's of both of my colleagues who are so involved in each of their individual bar associations. The practice of law is an extremely social practice. You meet people every day, and you never know who these people are going to be. I like to say I know every lawyer in Suffolk County. That's not true. How many lawyers do we have, Cornell? About 8,500 in the county that are members? About 8,500. I probably know about 1,000. The 1,000 that I know, obviously, it's from being in the courts day in and day out for 45 years. But it's also because I, like my colleagues, joined, in my case, my local bar association, and I'm pointing to Suffolk. It's critical that you understand the practice is not simply writing papers, filing papers, or appearing somewhere. It's getting to know your colleagues. You will meet the most interesting people, and my only suggestion again is you must join a bar association as a law student to gain full advantage and to meet the people who are ultimately going to interact with you. And so I urge that you do that, and thank you very much. Thank you. Should we next begin with announcing the winners? Okay. This was an extremely difficult decision. I myself have sat in this room with this type of competition many, many times, and I find myself incredibly, incredibly shocked how polished, how professional, and how well presented our students are. Take it from somebody like me. I was, among many things, an appellate lawyer. I probably argued, just in the appellate division alone, 250 different times. In the Court of Appeals, 25 different times. So I've seen many, many, many lawyers of different abilities. Both of you are just fabulous in terms of your presentation, your professionalism, and your ability to conduct yourself as true appellate advocates. And so it's truly a credit to the program and to the law school that we have you. Now, to the moment of truth. It was the most difficult of decisions. Our task is not to rule on the winner of the appeal, but to make a decision as to which lawyer was, quote, the better lawyer in terms of his or her presentation. Our decision, after much soul-searching, was Ms. Tamargo. Congratulations. Mr. Cohen, great job as well. And there should be no question, Mr. Cohen and I are not related to each other. We also would like to just briefly provide a little critiquing, and I think each of us will talk about that right now.
Can I lead?
Justice Baus?
Can I lead?
Sure, of course. Of course. Justice Glover.
One piece, I love the aggression. Government, 100%. Toro, 100%, as far as let's get to it. I mean, that's how we are taught to be well informed on the law and the facts. One thing we have to do is learn in practice as attorneys is temperament, and it's the how we communicate. And it's too much aggression, as in you're wrong, is too much aggression. When we communicate to the court, it's only deference. You can make a record, and you can make it respectfully, but there's only deference to the court. When questions are asked, for both of you and for everyone listening, we're looking for the responses, because I try to let you know I'm struggling with a particular point. You help me with that point, then I can probably help you with your case. So we are looking for direct responses on the particular points. The work that both of you put into this, I did not know how you were going to answer the aspect of her waiting in her mens rea, her state of mind, to not go into the home, waiting for the person to leave, and you nailed it. I was just thrilled because I'm thinking I should know the answer, and I could not for anything come with the answer, and each of you gave law, fact, but you're very creative in your responses, and that's what we're supposed to be doing on the other side. So my compliments to both of you.
And Justice Baus.
Thank you. And I do have to compliment both of you. You know, sometimes we seem pretty poker-faced up here, but it's difficult, when we have to choose, one or the other. I like the way you warmed yourself to the court, because one of the oldest tricks of the old trial attorneys from back in the day was make the jury like you. And if you make them like you, they're going to want to go in your favor. And I'm not saying that necessarily happened here, but it's one of the old tricks from the old trial lawyers, right? So what I would suggest on your end, Mr. Cohen, you had the facts on your side. So when you came at us like that, anytime I have to criticize a court or say, well, listen, this is with all due respect, Your Honors. This is what I think. And then you almost act as if you don't even want to say it, but I got to say it, something like that. You didn't do that. You kind of came at us, which I respected. I respected that. And there were times to do that, like on cross-examination. You want to go after that witness. But when you're talking to a jury or a panel of judges, you want to warm yourself to them. And you say, I've thought a lot about this, but with all due respect, it might have been wrong, something like that, right? So, but you knew the facts, you knew the law, and I'll agree with my adversary, my colleague, that very creative. Now, when we were done listening to you, you had this calculated woman, who was waiting for him to leave so she could rip him off, So I thought that your arguments were good. I have constructive criticism. And it wasn't only me. I think that I would ask a question, and you had a very good way of not answering it and going to something else. Now, that's very typical lawyer stuff. That's very good. But again, when you're talking to the individuals, the judges in this case, that are going to render a decision, like was mentioned earlier, you really want to answer their questions. You can put your spin on it, but you got to answer that question. So I would say that, and I have to compliment Mr. Marco, because you did answer the questions, and in your approach, I think you drove home the humanitarian aspect of it, and I think that you drove home the idea that where was the substantial risk? You didn't say it, and I don't think you could say it, but maybe it should have been charged as like a grand larceny and a criminal trespass as opposed to a burglary. But it was very clear in the instructions we weren't allowed to touch that. We had to accept this was a conviction for burglary, and you maintain that, and you fought for your client very hard. So that's what I think. Thank you.
I, too, will add to what my colleagues said. Both of you were as professional as you could be arguing tomorrow as appellate lawyers. Mr. Cohen, there but for the grace of God, was me as a young lawyer with a full head of hair and a black mustache almost 50 years ago. When you argue in the state courts, the first place you go is the appellate division. They're fabulous. It's the busiest appellate court in the United States. And they're a hot bench. And sometimes they can push your buttons to react in a way that maybe is not the way we should. And so yours truly would sometimes be that lawyer over a long run. And it takes a long time to make a decision that whatever I say, I'm going to say it in a way that's going to be so civil, and they're never going to see me sweat. What they're going to see is, with all due respect, the decision in Sessions should be reconsidered. And it was, after all, only a 5-4 decision. And so that sort of thing, rather than saying you were wrong again, or it was robotic in nature, that's like, what? And
That hurt.
so, in the end, most respectfully, you are to be applauded for your zealous appellate advocacy. But at the same time, as we went along, I was, as they say in legalese, in equipoise. What does that mean? It's 50-50. I'm on the fence. What ultimately proved the day is, in the end, when you stood up on the reply, now you know you've got 1 minute. Now, we're not going to cut you off. We're not going to say, sit down, you're through. But in that 1 minute, you did 3 arguments, and you were obviously listening to your opponent, and it was brilliant. And I will echo what Justice Baus said. You warmed up. In the beginning, you know, it's a scary thing. All of a sudden, I've jumped out of that plane, and I'm skydiving for the first time, and here I am, I'm out there. And for those of you in the audience wondering, can I do this? It's like running a marathon. Any of you can do this with proper motivation. I mean, you got to want to. But the other thing is the preparation. And this school is fabulous at providing you with that ability to do just what you saw today. It's the most wonderful of opportunities. And you get it, quote, for free. I know it's part of your tuition, but you get it for free, meaning the experience, without really involving yourself in, quote, a real client whose life literally depends on, is she going to stay or is she going to be deported? But both of you, again, were just fabulous. And I am envious because I know I couldn't have done this as a 3L. No way. So, excellent. Thank you.
Thank you.
Thank you, judges, for your excellent feedback and your deliberations. We would like to thank you for the time to come here today on behalf of the Moot Court Board. Thank you for coming. This event would not have been possible otherwise.
Thank you for having us.